Greetings. I thought that I would share this speech that I delivered in front of the St. Joseph County Conservative Voices, as they had invited me to speak at their President's Day breakfast that was held on Saturday, February 8th, 2025 in St. Joseph County. I hope you find it entertaining and informational. The Presidency: Power, Constraints, and Modern Implications. President's Day Breakfast Speech. Good morning, ladies and gentlemen. It is an honor to stand before you today as we gather to celebrate President's Day, a day set aside to reflect on the highest office in our land, the President of the United States. This is more than just a day to remember Washington, Lincoln, and the many who followed. It is an opportunity to examine the power vested in the presidency, the intended checks and balances, and how those restraints, both legal and practical, have morphed over time. The office of the president was never meant to be a monarchy, nor was it meant to be a powerless figurehead. Instead, it was designed with a delicate balance of authority and accountability, a balance that has been tested, challenged, and in some cases, redefined throughout our nation's history. Today, I invite you to journey through the constitutional origins of presidential power, tracing it back to the framers' intent, not through modern reinterpretation, but through the very words of the founders themselves. We will examine instances where presidents have acted beyond expected constraints and discuss whether those actions were justified or violations of constitutional principles. Finally, we will address the current legal and political debate surrounding presidential immunity, particularly in light of the recent Supreme Court ruling involving the then former President Donald Trump. In an era where executive power is both wielded and challenged with increasing intensity, it is crucial that we, as an informed people, understand the foundations of that power and its modern implications. Before we can properly analyze these topics, however, we must first agree on certain self-evident truths about the Constitution's founding and the unique system of government it created, a compound republic. This is not a matter of opinion or interpretation. These are historical facts, proven through the words of the founders themselves. And while these truths may be inconvenient or even ignored in today's political climate, they remain the bedrock of our constitutional order. With that in mind, let us begin. The first self-evident truth: no branch of government has authority over another branch of government. In the different Federalist Papers, written by the framers of the Constitution, highlights this truth in the following Federalist Papers. In Federalist number 47, written by James Madison, in which he said, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." In this quote, Madison explains the importance of separating powers among the three branches to prevent tyranny. No branch should exercise control over another. In Federalist number 51, written by James Madison, in which he said, "In order to lay a due foundation for that separate and distinct exercise of the different powers of government, which to a certain extent is admitted on all hands to be essential to the preservation of liberty, it is evident that each department should have a will of its own." In this quote, Madison argues for the independence of each branch, ensuring they operate within their own distinct sphere of authority. Madison writes on in the same paper saying, "Ambition must be made to counteract ambition. The interest of the man must be connected with the constitutional rights of the place." This highlights how the separation of powers ensures that no single branch becomes dominant, as each checks the other. In Federalist number 48, written by James Madison, in which he said, "It is equally evident that none of the branches ought to possess, directly or indirectly, an overruling influence over the others in the administration of their respective powers." Madison stresses that the powers of the branches must be balanced to preserve their independence and prevent encroachment. In Federalist Number 78, written by Alexander Hamilton, in which he said, "The judiciary has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment." Hamilton explains that the judiciary is the weakest branch, tasked with adjudicating the laws but lacking enforcement powers, sword, or financial control, purse. In Federalist Number 69, written by Alexander Hamilton, in which he said, "The President is to be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the Union." Hamilton defines the executive's power of the sword, underscoring its distinct and separate function from the legislature and judiciary. In Federalist Number 70, written by Alexander Hamilton, in which he said, "Energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks. It is not less essential to the steady administration of the laws, to the protection of property, and to the security of liberty." Hamilton highlights the executive's active and energetic role, distinct from the more deliberative functions of the legislature. In Federalist Number 58, written by James Madison, in which he said, "The House of Representatives cannot only refuse, but they alone can propose the supplies requisite for the support of government. They, in a word, hold the purse." Madison emphasizes the House of Representatives' exclusive control of the purse, an essential check on the executive's power of the sword. In Federalist Number 79, written by Alexander Hamilton, in which he said, "Next to permanency in office, nothing can contribute more to the independence of the judges than a fixed provision for their support." In this quote, Hamilton reinforces the importance of judicial independence to maintain neutrality and separation from political pressures. Key points supported in these papers. 1. Separate but equal powers. Each branch is designed to be independent, with its own defined powers to prevent tyranny. Federalist Numbers 47, 48, and 51. 2. Distinct roles. The legislature controls the purse and has impeachment powers. Federalist Number 58. The executive wields the power of the sword. Federalist Numbers 69 and 70. The judiciary is neutral, adjudicating the law without enforcement power. Federalist Number 78. 3. Checks and balances. The branches are structured to check each other without subordinating one to another. Federalist Numbers 47 and 51. The second self-evident truth that we must agree on to have a productive discussion and proper understanding of the office of the President is, the Supreme Court is not the final arbiter of what is and is not constitutional. Because the Constitution is in fact a contract, or better understood as a compact, we must understand the ancient legal contract doctrine called the meeting of the minds. The doctrine of meeting of the minds in contract law, coupled with founding era writings, supports the principle that the people are the ultimate masters of the law and have the final say on what is or is not constitutional, not the Supreme Court or any single branch of government. Let's explore this in two parts. First, the legal doctrine, and second, founding documents and writings that address the sovereignty of the people. Part 1. Legal Doctrine, Meeting of the Minds. In contract law, the principle of a meeting of the minds establishes that a valid agreement requires mutual understanding and consent between the parties involved. This concept is foundational to the rule of law and reflects the idea of collective consent in a republican government. Definition of meeting of the minds. The meeting of the minds refers to the mutual agreement between parties regarding the terms and obligations of a contract. It is a cornerstone of enforceable agreements and stems from the broader principle that agreements must be based on mutual consent, clarity, and understanding. Restatement of Contracts, 2nd edition, Section 17, Subsection 1. The formation of a contract requires a bargain in which there is a manifestation of mutual assent to the exchange and a consideration. This principle can be analogized to the constitutional system, where we the people are the primary parties to the contract, i.e. the Constitution. The people's understanding and consent to the structure of government are paramount. Marbury v. Madison, 1803, Chief Justice John Marshall acknowledged the centrality of consent and agreement to the rule of law when he said the powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. Marshall's reasoning underscores that constitutional limits are not for the judiciary alone to interpret, but are grounded in the will of the people. Now in Part 2, we will investigate what the founders wrote in various writings. This will be broken down by the Declaration of Independence, 2 Federalist Papers, a letter from Thomas Jefferson, along with what he wrote during the Kentucky Resolution of 1798, and Lincoln's inaugural address in 1861. Part 2. Founding Principles. The People as Masters of the Law. A. Declaration of Independence. The Declaration establishes the principle that government derives its power from the consent of the governed. Governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. This passage asserts the people's ultimate authority over the government and its laws, including their interpretation of the Constitution. B. Federalist Papers, in Federalist Number 49, written by James Madison. Madison explicitly recognizes that the people, not the branches of government, hold the ultimate authority. Madison wrote, "The people are the only legitimate fountain of power, and it is from them that the constitutional charter, under which the several branches of government hold their power, is derived." This reinforces the idea that any disputes over constitutional interpretation ultimately rest with the people. In Federalist Number 78, written by Alexander Hamilton. While Hamilton discusses the judiciary's role in interpreting the Constitution, he acknowledges that judges themselves are subordinate to the people. Hamilton wrote, "The judiciary may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments." This passage shows that judicial authority is not absolute and remains subject to the people's will. C. Thomas Jefferson. Jefferson repeatedly affirmed the sovereignty of the people over their government and its laws. Letter to William Charles Jarvis, 1820, Jefferson wrote, "To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and the privilege of their corps." Jefferson warns against judicial supremacy and asserts that the people must retain the ultimate authority over constitutional matters. The Kentucky Resolution, 1798. Jefferson argued against federal overreach and for the people's authority to determine the constitutionality of laws. Jefferson wrote, "The government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the Constitution, the measure of its powers." Here, Jefferson refers to the Constitution as a compact between the states, and by extension, the people, where each party retains the right to interpret and enforce its meaning. D. Abraham Lincoln. In his first inaugural address, 1861, Lincoln reaffirmed that the Constitution derives its authority from the people. Lincoln said, The people of these United States are the rightful masters of both Congresses and courts, not to overthrow the Constitution, but to overthrow the men who pervert it. This statement emphasizes that the judiciary is subordinate to the people and that constitutional interpretation remains their ultimate responsibility. 3. Practical application of sovereignty. The structure of government, as outlined in the Constitution, reflects a compact theory rooted in mutual consent. The people, the source of all political power, as explicitly stated in the preamble. Townships and counties, local governments derive their authority from the states, ensuring that power is decentralized. State governments, sovereign entities within the federal system, acting as intermediaries between the people and the national government. Federal government, a creation of the states and the people, limited by enumerated powers. The layered structure ensures that no single branch of government, including the judiciary, can claim final authority over constitutional interpretation without accountability to the people. Now that we agree on those two self-evident truths, I will continue with my discussion on the constitutional origins of presidential power. Instances in history where presidents acted beyond their expected constraints, and the current legal debate surrounding presidential immunity. 1. The constitutional foundation of presidential power. The powers of the president are derived from the U.S. Constitution, specifically Article 2. Our founding fathers debated extensively on the role of the executive, ultimately crafting an office that would be neither a monarch nor a powerless figurehead, but an independent and robust force within government. 1. Article 2, Section 1, Clause 1, establishes the executive power in a single president. In short, the executive power is held by the president, who serves a 4-year term, elected alongside the vice president for the same term. 2. Article 2, Section 2, Clause 1, declares the president as the commander-in-chief of the Army and Navy, ensuring the executive has authority in military affairs. In short, the president is the commander-in-chief of the military and state militias when called into service. He can ask for written opinions from department heads, and he has the power to grant pardons, except in impeachment cases. 3. Article 2, Section 2, Clause 2, grants the president the power to make treaties and appoint judges, ambassadors, and other public officials, with the advice and consent of the Senate. In short, the president can make treaties and appoint key officials, like ambassadors and judges, with Senate approval. Congress can allow the president to appoint certain lower-level officers on his own. 4. Article 2, Section 3. The president is required to take care that the laws be faithfully executed, which is the cornerstone of executive enforcement power. In short, the president must update Congress on the country's condition, suggest necessary actions, and may call Congress to meet. He can also settle disagreements between houses on when to adjourn, receive foreign ambassadors, ensure laws are followed, and appoint U.S. officers. The Federalist Papers, particularly Federalist No. 70 by Alexander Hamilton, argue that a single, energetic executive is essential for good government, ensuring decisiveness, accountability, and strength in national affairs. Hamilton wrote, "A feeble executive implies a feeble execution of government. A feeble execution is but another phrase for a bad execution, and a government ill executed, whatever it may be in theory, must be, in practice, a bad government." In summary, the power that the office of the presidency, as prescribed by the Constitution, are Commander-in-Chief, leading the armed forces. Article 2, Section 2, Clause 1. Chief Diplomat, negotiating treaties and engaging with foreign nations. Article 2, Section 2, Clause 2. Chief Executive, enforcing federal laws and overseeing the executive branch. Article 2, Section 1, Clause 1. Legislative participant, possessing the power to veto legislation. Article 1, Section 7, Clause 2, 2. Presidential power beyond the constraints of other branches. While the system of checks and balances aims to prevent any branch from becoming too powerful, there are instances where the president can act with little to no constraint from Congress or the judiciary. 1. Federalist Paper Number 48. James Madison argues that branches of government must have overlapping powers to prevent tyranny, but acknowledges that the executive has areas of autonomous authority. Madison writes, "It will not be denied that power is of an encroaching nature, and that it ought to be effectually restrained from passing the limits assigned to it." 2. Federalist Paper Number 69, Alexander Hamilton, distinguishes the president's powers from a monarchy, yet emphasizes strong unilateral authority in areas such as foreign policy and military command. Hamilton writes, "The President of the United States would be liable to be impeached, tried, and upon conviction, removed from office, and would afterwards be liable to prosecution and punishment in the ordinary course of law." 3. Federalist Paper Number 70 reaffirms the necessity of a strong and decisive executive, particularly in times of crisis. Hamilton writes, "Energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks. It is not less essential to the steady administration of the laws, to the protection of property against those irregular and high-handed combinations which sometimes interrupt the ordinary course of justice, to the security of liberty against the enterprises and assaults of ambition, of faction, and of anarchy." Historical examples of unconstrained presidential action. Andrew Jackson versus Chief Justice John Marshall, 1832. The Supreme Court ruled in Worcester versus Georgia that the state of Georgia could not enforce laws on Cherokee lands. President Jackson allegedly responded, "John Marshall has made his decision. Now let him enforce it." Jackson refused to enforce the ruling, demonstrating the limits of judicial power when the executive refuses compliance. Abraham Lincoln and Habeas Corpus, 1861. During the Civil War, Lincoln suspended the writ of habeas corpus without congressional approval. When the Supreme Court, led by Chief Justice Roger Taney, ruled in Ex parte Merryman that only Congress had the power to suspend habeas corpus, Lincoln ignored the decision. Franklin D. Roosevelt and Japanese internment, 1942, FDR issued Executive Order 9066, which led to the internment of Japanese Americans during World War II. The Supreme Court upheld this action in Korematsu v. United States, demonstrating judicial deference to executive wartime authority. 3. The recent Supreme Court ruling on Trump and presidential immunity. In the ongoing legal battles surrounding then-former President Donald Trump, the Supreme Court has recently ruled on the scope of presidential immunity. Absolute versus presumptive immunity. The court clarified that while a president enjoys absolute immunity for core constitutional functions, there is only a presumption of immunity for other actions taken in office. This distinction protects the president from legal persecution for official duties, but does not grant blanket immunity for all actions. Democratic hypocrisy on presidential power. The same Democrats who argue that Trump should be held accountable for actions taken while in office defended President Joe Biden's executive overreach on multiple fronts, including immigration laws. Biden ignored judicial rulings on border security and refused to enforce federal immigration laws. Financial laws. The Biden administration's student loan forgiveness plan was struck down by the Supreme Court, yet the White House continued to push through alternative means. Weaponization of the Justice Department. The Biden DOJ has been accused of selective prosecution, pursuing Trump aggressively, while downplaying or ignoring allegations against Hunter Biden and others within their political circle. The inconsistency in these positions reveals that many critics of Trump's actions are not principled defenders of the Constitution, but partisan actors seeking to weaponize the legal system against political opponents. 4. What are the remedies? When the presidency does not enforce the laws, the Constitution grants no direct enforcement powers to the judiciary or the legislative branch over the executive. However, the founders anticipated such scenarios and provided remedies. 1. Congressional remedies, impeachment, Article 1, Section 2, and Section 3. The House of Representatives has the sole power of impeachment, and the Senate holds the trial. Federalist Number 65, Hamilton, discusses impeachment as a check against executive misconduct. Hamilton wrote, "The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself." Power of the Purse, Article 1, Section 9. Congress can restrict funding to executive agencies, limiting enforcement capabilities. Legislative oversight. Through hearings and subpoenas, Congress can investigate executive inaction and apply political pressure. 2. Judicial remedies, mandamus writs. In Marbury v. Madison, 1803, the court established judicial review, but has limited enforcement power over the executive. Court rulings and injunctions. While courts may rule against executive inaction, history shows enforcement is dependent on the president's willingness to comply. 3. Other constitutional remedies, state action and nullification. States have occasionally resisted federal overreach or inaction by asserting their rights under the 10th Amendment. Thomas Jefferson discussed nullification in the Kentucky Resolution of 1798, where he argued that states have the right to nullify federal laws they deem unconstitutional. Here's a key quote. Resolved that the several states composing the United States of America are not united on the principle of unlimited submission to their general government, but that, by compact under the style and title of a Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Jefferson argued that since the federal government derives its authority from the states have the power to judge the constitutionality of federal actions and reject those they deem unconstitutional. Citizen action. The people ultimately hold power through elections and public pressure. In conclusion, the presidency remains one of the most powerful offices in the world, shaped not only by the Constitution, but also by historical precedent, political necessity, and at times, the willful expansion of executive authority. While checks and balances exist, history has repeatedly demonstrated that presidents, when faced with crises or political opposition, have wielded power beyond the reach of Congress and the courts. Some of these actions have been justified as necessary for the survival of the nation, while others have set dangerous precedents that test the very limits of constitutional authority. Yet no matter how powerful the office of the president may seem, ultimate authority does not rest in Washington, D.C. It rests with we the people. The founders designed a government where the people were not meant to be passive observers, but active participants, holding their elected officials accountable to the Constitution's original intent. It is not up to Congress alone to rein in executive overreach. It is not up to the courts to single-handedly defend our liberties. It is the duty of the American people to demand fidelity to the Constitution and ensure that our elected officials govern within the bounds of the law. This truth was understood from the very beginning. As Benjamin Franklin emerged from Independence Hall at the close of the Constitutional Convention, a woman reportedly asked him, "So, Dr. Franklin, what have you given us?" Franklin's reply was both profound and prophetic. "A republic, ma'am, if you can keep it." Those words ring as true today as they did in 1787. The survival of our republic does not rest in the hands of politicians, judges, or bureaucrats. It rests in the hands of the people. We cannot expect those in power to voluntarily limit themselves. It is our responsibility to demand it. And what is the remedy for a government that has exceeded its bounds? The founders gave us the answer: the ballot box. The last election, and every election, is a constitutional safeguard, a means by which the people can correct the course of an out-of-control government. But elections alone are not enough. If we become complacent, if we fail to hold our elected officials accountable, then Franklin's warning will become our reality. In the end, it is not presidents, Congress, or the courts that will determine whether this nation remains free. It is us. We, the people, are the last safeguard of liberty. We, the people, are the final check on government power. And only we, the people, can save our republic. So, as we reflect on the presidency and its immense power, let us remember that our duty does not end with discussion. It begins with action. If we truly wish to keep this republic, then we must be willing to stand, speak, and hold our government to the principles upon which it was founded. May we rise to that challenge. Thank you. May God bless you, and may God always bless America.